ask, and it's so obvious to us lawyers that we really don't reflect on it, is what is a will? We use the term all the time. A will actually is a legal document that is a directive for what happens to your property, to your estate, and as Bill has mentioned in some instances, to the guardianship of your minor children after the time of your death. People who come into the lawyer's office have already made the first step toward drawing a will. There are a number of other people who attempt to write wills for themselves who do not go into the lawyer's office. So I think maybe the first thing that we may need to look at in not what is a will and how do we get a will is to tell you that under Kentucky law there are basically two ways in which we may draft a will. Kentucky does allow what we call a holographic will, which means one that is wholly drawn in the handwriting of the person who's making the will. That person is called a testator. He may sit down and from beginning to end write out what he wants done with his property. There are lots of funny cases in Kentucky. People have even written wills on brown paper bags, and they have been accepted by the court. But the problem with that is that a person who's attempting to write his own will and who does not have a legal background oftentimes says many things that he doesn't intend to say. He thinks that he's giving a direction that his property go in one area, when in truth, in fact, he's using language with which he may not be familiar, and he gives another direction. I know Ruth and I were involved in a case where a school teacher attempted to write her own will. And I don't know if Ruth remembers this or not, but she put some language in the will that we had to go to court with, had to interpret, and it was very expensive litigation. I'll talk to you in a few minutes about the cost of a will, but this woman could have saved her estate hundreds of dollars had she gone to a lawyer and had the will properly drawn, rather than trying to do a holographic will or one that she did wholly in her own handwriting. So my first advice to you is to do a will. The second one would be don't attempt to do it by yourself. Go into your lawyer's office. Basically, as I said, there are two ways. One is the handwritten will. The other is one that's done with witnesses, and that's the kind of will that we do in the lawyer's office. We talk to the client, you tell us what it is that you want, and then the lawyer reduces to writing the will, and it is properly witnessed. In Kentucky, we require two witnesses to a will, and they must sign that will in the presence of the person who's making it and in the presence of each other. And that is very important. In fact, making a will and following the legal procedures is something that your lawyer knows how to do and that you should do with him. Because if you do not have the will properly witnessed, it will not be subject to probate. And I think Ruth is going to talk to you about that in a few minutes with regard to probate procedures. But so again, we have the two methods, and the latter one is the one that we recommend. See your lawyer, have a will, have it properly witnessed by those persons that the law requires. What, in addition to the procedure, what is it that you're going to put in your will? What you want to do basically is dispose of your property the way you want to do it. Telling your lawyer exactly what you want to accomplish, and your attorney will do his or her best to meet those needs and to advise you as how you can best accomplish your purpose. You need to list your beneficiaries, all those persons to whom you want your property to go. As Bill has indicated, there are a number of things that you should mention specifically. If you want your diamond ring to go to your daughter, say so in your will. If you want your guns to go to your son, have that put in your will so they will specifically be mentioned and those persons will benefit and get those items of your property that you want. And then lastly, whatever property is left after you have left those specific bequests, you need to leave to the person of your choice. It may, in most instances, we find that husbands and wives, after they make those specific bequests, are inclined to leave property to each other. But in your will, you need also to realize that husbands and wives oftentimes die simultaneously. And that's particularly true in this day and age when we use the automobile so much, and simultaneous deaths are very common. So you need to advise your lawyer as to what you want to happen should that event occur, that you and your husband or wife are in a common accident, you both die together, and then where's the property to go? Generally, again, that would be to children if you have children. And I think Bill has already pointed out that when you leave the property to your children, if they are minor or under the age of 18, then you need to make provision in that will for somebody to be a guardian of that property and a guardian of the person of the child. And you can do both. You can appoint someone who is a relative to take care or be a guardian of the person of your child. You can appoint somebody else or the same person to take care of or be the guardian of that child's property after the time of your death. You also in your will want to name some person as an executor. That's the name that we give to that person who is going to take care of the estate after your death. Whereas husbands and wives most frequently name each other, we advise that only when we know that you're going to be consulting with a lawyer and the lawyer is going to be helping you to manage the estate. Because you need to have somebody who's going to handle your affairs whom you trust implicitly, somebody who has some business knowledge, and someone who would be able to gather your assets and see that your wishes in your will are carried out under the direction of the court. It's also, as we've mentioned earlier, in your will it's possible for you to do things that may minimize the burden of taxes on your estate. And I'd like to say this, I have a number of people who come in my office who want to deed their property away, excuse me, or give their property away because they think that this great tax burden is going to descend on them at the time of their death. I think they need to talk to their lawyer and find out that tax burdens at the time of your death, unless you have a very substantial estate, are not so great that that those sorts of tax-saving measures are necessary. But you do need to consult with the lawyer who may help you to put tax-saving measures in your will or to send you to an estate planner who may help you with that aspect of it. The last thing that I want to mention has to do with the cost of the will. Writing a will, as you may, I hope, already see, is something that is very important that you do if you wish your property to go in the direction that you want it to go to those persons that you wish to have it after the time of your death. The cost of writing that will is very minimal. It's not going to cost you a whole lot more than having a deed drafted for the sale and transfer of your real estate. It's probably one of the cheapest things that your lawyer ever does, and one of the most valuable tools that he uses in order to help you. Ruth is now going to tell you what happens after the time of your death when you have drawn your will and that will is ready for you to take to the court for probate.
Thank you, Irene. We call the procedure where one presents a will before a judge probate, and you've probably heard of the term that I'm going to probate court. One of the myths that people use as an excuse not to have a will is they say, I can avoid probate court by not having a will. But that's not the law in Kentucky. Whether you die with or without a will, there is a procedure to go through probate court for the district judge in your local county to review the situation and to determine what needs to be done in order to handle your estate. Now, the word estate sounds like a big word that we're talking about millions of dollars and a lot of property. But in Kentucky, an estate refers to anything that you own at the time that you die. That may be a house that you own with your spouse. It may be your car, your furniture, a bank account that you have at a local bank, or even a pension or retirement plan that you have at your place of business. All of these items come together and form your estate. Now, when you die and when you have a will, the procedure for handling your estate is simplified.